Good afternoon, Your Honor. Cheryl Luckoff on behalf of the plaintiff.
All right, I think Miss Parrish is here present. Is that you?
Nicole Parrish on behalf of Nicole Parrish and all other occupants.
Okay. All right. Where are we on the, go ahead.
Welcome back to another intense courtroom showdown. Today's case brings drama, desperation, and damage quite literally. On one side, we've got a tenant who claims she lived without a working shower for nearly 3 months, forced to bathe elsewhere and clean up drywall debris caused by a busted ceiling. On the other, a landlord demanding $2,241 in unpaid rent and pushing for eviction. The judge.com, but ready to cut through the noise. As emotions flare and tensions rise, you'll see how a plea for basic living conditions collides with cold, hard legal deadlines. Stick around because this one is full of twists, blame games, and a judgment that may leave you questioning. Is justice always black and white?
Where are we on this case, Ms. Luckoff? What's the
Your Honor, this is a non-payment of rent action. The defendant had submitted the DC 539 that she had applied for rent assistance. She also filed an answer indicating that there were some repair issues. I've had a chance to look into this, and all of the repairs have been done. She submitted with her answer an email to my client, which was not to my client, but I don't want to get too far into the weeds here. The balance right now is $2,241.10. So I don't know where the rental assistance application stands. So I guess we should perhaps start with
The
that.
rental application stands. I have an appointment with them next week to get a phone. I'm supposed to have a phone call appointment with them next week.
Here's where it gets interesting. The tenant's not just dodging rent. She's filed for emergency relief and is actively working with the Michigan Department of Health and Human Services. But she's also making a compelling argument. From March to May, they had no working shower. That's not a minor inconvenience. It's a violation of habitability standards. In many jurisdictions, tenants can seek rent abatements for uninhabitable conditions. But proving that in court, that's another beast. What do you think? Should landlords lose rent over repair delays?
To get it verified, but from the sounds of it, it's
which one? Hawk?
no, MDHS, I think it is the Michigan Department.
Gotcha.
Yep.
Because you filed a
I filed-
state emergency relief.
Yeah.
Okay. All right.
I put it in the information. However, we feel that it is fair that there is an abatement on rent because for some of it, not all of it, because from March 5th to May 23rd, we had no shower, no usable shower because there was a hole in our ceiling that they neglected to fix. And I'm sorry the email went to the wrong person. From what I know, Wendy is the person that I've been told to contact. So Wendy is who I sent the email from because she is the one that gave me her business card. And then on top of that, we not only have had to find another place to shower, we've had to spend the gas money and all of that to get to a new place to shower.
Okay.
And then
This moment is raw. The tenant isn't just talking rent, she's reliving months of hardship, forced to shower elsewhere and clean up construction mess on her own. It's clear she feels unheard, and the emotional toll is showing. But here's the legal twist. Unless that damage was formally documented and reported in time, judges often treat it as anecdotal. Courts rely on paperwork, not passion. Still, can you blame her for snapping under pressure?
on top of that, we had to clean all of the debris from something that we did not cause. So we had to clean the entire tub of all of the drywall and everything from the mess of the pipe bursting. They did not clean any of that. And in the picture, you can see that I submitted a picture of the tub.
Ms. Parrish?
And in the tub, there's
Ms.
just
Parrish?
straight clothes
Ms.
and
Parrish?
stuff.
Ms. Parrish, do me a favor. Take a breath. Okay.
Sorry.
No, it's okay.
Stressful.
I will, no, I know, and I will hear everything you have to say, but you were flying there for a minute.
I'm sorry. We've had no usable shower for basically 3 months. We've had
Okay.
to find a new place to shower, and then we had to go through the distress of cleaning
Okay,
everything out of
but
it.
hold on. Let me ask some questions. If Ms. Luckoff has indicated the repairs have been made at this point, correct?
They were made the 23rd of May, which is
Okay,
still from
but-
March to the 23rd of May. But they weren't bad.
Okay, I'll try that question again. As of right now,
Yes,
the
they're-
repairs were made. Thank you. That's what I need to know.
Yeah.
Because I want to make sure we're not dealing with something continuing. That's the reason for my question.
As of now, the repairs have been made only because she got 2 weeks to be able to talk to her plaintiffs and have her plaintiffs fix it.
Finally, Some clarity, the repairs have been made, but only after the court stepped in. That's a key detail. The judge is laser focused on whether the issue is ongoing, because that affects how much sympathy or leniency the tenant might receive. Repairs made after legal pressure suggest negligence, but also resolution. This is the moment the court shifts from how bad was it to what happens next.
Because it was fixed within the 2 weeks of the adjournment that you gave.
You just want to fight right now, don't you?
I just want to.
No, I know, but
I want some justice to be served about the fact that we did not have the shot.
I know, I hear you. I'm just, there's a process for me getting there, okay? And it's not like today what's gonna happen is everything's gonna be all resolved.
I understand. I knew that it wasn't all gonna be resolved.
Okay. So let's do this, because what was the total amount owing?
Your Honor, through today, it's $2,241.10.
This is a masterclass in judicial realism. The judge throws out a what-if scenario. Even if I reduced your rent by $421, would you still be able to pay the balance? Her answer, a mix of optimism and financial scramble. She's hoping for a loan and waiting for payday. But the court isn't a waiting room for hopeful outcomes. It needs certainty. This moment underscores just how thin the financial tightrope is for many tenants today. Question for you, should eviction cases allow more time for people to recover, or is the law the law?
And then tomorrow rent is going to click in.
Exactly.
So let me ask you this. Do you have June's rent to pay?
I will have part of it on the 6th. I will have it on the 6th. It will be late and there will be a late fee, but I will have it.
Okay, all right.
Because I don't get paid until the
Young lady.
Your Honor. Oh, sorry.
Okay, listen. And I just try to be practical about things, okay, in a way. All right. So I've got about 2,400 previous to tomorrow owing. All right. So just listen to my question. Even if I said, okay, and I'm not saying this, but even if I said, I'm going to give you an abatement of $421. So you owe $2,000. You don't have that, do you?
I will have part of it on the 6th, and then I'm also going to the loan office tomorrow to get a loan for the rest of it.
Okay.
So we also got put out of jobs and stuff because they had a fire that happened in February and we got displaced for 7 days. So I'm now trying to get back into employment and stuff. I've been trying to get back.
Okay, Ms. Parrish.
That's the moment everything changes. The tenant surrenders. No more fighting, just a plea to leave. It's okay if you kick us out. There's pain behind those words. And for the court, that signals the end game, possession over payment. What started as a battle over $2,200 ends with someone simply wanting peace. It's not about winning anymore. It's about escaping.
It is okay if you kick us out. We don't want to live there anymore. I'm going to be honest with you. We have other options.
Well, okay. So listen, they filed a judgment for possession.
Okay.
They just want possession.
They just want possession.
Okay. Just listen to me, please. Okay. They want possession of the premises, right? Now, there may be a claim that you might owe them money, but for right now, they want possession of the premises.
Okay.
Okay. My initial inquiry was trying to figure out how you might be able to get this paid, but it seems to me, I don't know that can happen right away or within the 10 days.
Yes.
And then you tell me it's okay if you want us to move. So do you want to move?
This isn't the first maintenance issue, and she wants the judge to know it. Cold nights without heat, showers without water. The pattern of neglect is being painted clearly. Unfortunately, courts often deal with this case. This day, past issues matter morally, but not always legally, and the judge is bound by what's in front of them. Still, her frustration is palpable and entirely valid. Would you stay in a unit like this?
We are, yes. We had talked to them and they said that as long as we got it paid off, we could put in a 30-day notice and we could get out of there. We just want out of there. This isn't the first time we've had problems with their maintenance not fixing stuff. We got left with no heat overnight, willingly known by their maintenance back in January. We just want out. So if they're just asking for possession, I thought they were asking for possession and the amount of rent, not just possession.
Well, they may later on be asking for rent,
Okay.
but I mean, I could grant them a possession judgment right today, and then you could be done with this part of it.
How many days do I have to get out then?
Well, that's how soon can you be out?
The 6th preferably, so I can have my check.
Okay, you'll have through the 10th.
Okay, so that can be doable.
Okay, so you don't have a problem that if I find that there isn't necessarily a tribal issue at this point, but entering into a judgment for possession, if you wanted to stay, you'd have to pay the 24.21, but
Yep.
sounds to me like you don't want to stay.
Legal moment here. The judge defines the redemption amount. That's the magic number the tenant would need to pay to stay. In this case, $2,421. If she pays it, she stays. If not, she leaves. The court is essentially saying, money talks. But she's made it clear she doesn't want to stay, even if she could pay. Sometimes the cost isn't just financial, it's emotional, too.
That would be your redemption amount, and a writ would issue in 10 days. That's okay with you?
Yes.
Any questions regarding
No.
that? You sure?
Yep, I want out of it.
Because you always have questions, it seems.
This line hits hard. That's the only thing I've wanted. I just want out. She's not asking for a fight, she's asking for freedom. And this kind of closure is what many tenants long for when the system feels too overwhelming. It's a sobering reminder. Eviction isn't always about bad tenants. Sometimes it's about broken systems.
You've
Yeah.
got a lot to tell me.
Because that's the only thing that I've wanted this whole case. I just want out of.
Okay.
I was gonna say, I've just wanted out of their apartment building.
Okay. All right.
So then what happens? How long will I know until they have a judgment? Can I ask how long will they, I guess one question, how long will I know until if I owe them that rent after?
Smart question. She's already thinking ahead. Even though she's leaving, she knows the landlord might still pursue her for the back rent. The judge doesn't rule on that today, but offers sound advice. Communicate, arrange a payment plan, get it in writing. Because once you're out of the unit, the financial chapter often begins, not ends. This is a lesson for anyone renting. Leave the apartment, but don't leave loose ends.
I'm sure they'll be in contact with you, or what you might want to do is the best thing to do is contact them
Okay,
and try to work something out. They may give a concession for it. They'll say, do this. The great thing about trying to do it that way is that then if there has to be a payment plan for whatever amount is owed,
okay,
you can try to work that out with them at the same time.
okay.
Make sense?
Then, yep, that makes sense. And then, so I have 10 days to get out and then I'm guessing I return the keys to them.
Yes.
Okay,
You would need to make sure that you return the keys to
to
them.
them. Yep,
Okay.
okay.
So judgment to the plaintiff for possession, redemption amount $2,421. That includes costs, correct? Ms.
So-
Nickoff?
Actually, Your Honor,
one
it's
last question.
2,200.
And there it is, judgment granted. The plaintiff gets possession, the tenant gets 10 days to leave. No arguments, no delays. The WR the judge refers to, that's the writ of restitution, the official eviction order. Once it's issued, enforcement can begin. This courtroom moment may seem quiet, but legally, it's seismic. It's the beginning of the end for this tenant's tenancy.
$41.10.
2,241.
Yes,
Okay.
yes.
So then, since they're getting possession,
With
the
the writ
June
issue
rent
in 10
won't
days.
be added on to that?
They may, so here's the thing. You're going to be occupying the premises for June. This judgment's not going to.
So if I'm out by June 1st though?
You have to talk to them about that.
Okay.
I can't deal with June
Okay.
because it's not here yet.
Okay,
Okay?
Yep.
I'm just gonna grant the judgment. Right?
okay,
Writ to issue in 10 days. And then I'm just gonna suggest that you talk to the landlord.
Okay.
Okay? And see what you guys can work out.
Okay.
Fair enough?
yes, thank you.
All right. So I'll sign that judgment when it's presented. Ms. Parrish, thank you.
This courtroom drama ended not with a fight, but with surrender. The tenant lived months without basic amenities, scrambled for rent assistance, and ultimately asked to be released from the lease. The judge granted a possession judgment, and while the landlord may still seek unpaid rent, the eviction clock is now ticking. This case highlights the brutal intersection of tenant rights, repair responsibilities, and financial stress, all playing out in real time. What do you think? Should landlords be held more accountable for repairs before demanding rent? Or was this just a case of too little too late? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. We've got more real-life drama headed your way.